Hello, all the CA Foundation students. Now, this is a time to make a super quick revision of the last two chapters of general contracts, being the contingent and quasi contracts and breach of contract. From the questions itself, directly I will explain you the concept and try to complete it as soon as possible. I'm not going to kill your time. This is definitely going to add value. Okay, so you can see these all questions were tested multiple times in examination. So therefore, let us go by question banks as that we are directly tuning ourselves to the ICA while doing this super quick revision. Okay, separately you need not read concept again and waste your time at this moment. Complete this. First one, explain the term quasi contract and state their characteristics. Okay, what is a quasi contract? That's the question. So under special circumstances, obligation resembling those created by contract or imposed by law, although parties have never entered into contract. Means example, what you need to write, though really there is no contract created, but something similar to that of contract is created. Means though there is no contractual obligation between two parties, okay, there is a obligation that is resembling like that of a contract. Such kind of situation we call as a quasi contract. Quasi means it's look like a contract, but really there is no contractual obligation. Okay, such obligation imposed by law is called as quasi contract. Such contract resembles with a contract so far as a result, a result or effect is concerned, but it has little or no affinity with the contract in respect of mode of creation. Sir, what is all this? By creation, it is not a contract. Whenever you wanted to create a contract, what are the essential requirements? There must be two parties. One party should be having knowledge of another party. One person will give offer, another person will give acceptance. It becomes a binding promise. Promise when agreed, it becomes agreement. Imposed by law when it is said okay, it becomes a contract. These all things will not be there in a quasi contract. Means when it comes to mode of creation of a contract, quasi contracts are having either little connection or even no connection with the general concept of a contract. Okay, that's the second point you need to write. So what is the first point? Under some certain special circumstances, obligation resembling like that of a contract will be created, though really there is no contract. Number one. Okay, those are called as a quasi contracts. Point number two. Point number three, as far as relating to the contract, okay, there is a little or no relation with that of the general mode of creation of a contract. Okay, examples or salient features. What are the features of a quasi contract? See how many times this was tested. What are the features of a quasi contract? It does not arise from an agreement. So first one, no agreement. Next one, duty and not promise is, okay, duty and not promise is based on is the basis of such contract. Means what? There is a duty, not a promise. Okay, duty not a promise is the basis of such contract. It is only a duty, no promise. Means what? Normally contract I will promise, you also give a reciprocal promise. Here duty will be there, not a promise. Okay, so what is the first one? No agreement. Second one, only duty, no promise. Number three, right under it always a right to money, and generally, though not always, to a liquidate sum of money. Reminding everything if you leave. Normally, contract law, what will be there? Performance is important. What is important? Performance is important. If performance is not done, it becomes a breach. Correct? Quasi contract law, performance is not there. There is only right to money. There is only right to money. Okay, next. Such right is available against a specific person and not against the whole world. Okay, and only against a particular person. Generally, invitation offer will be given to public at large. Whoever want, they can do. But quasi contract is only between two persons. It cannot be with any other person other than these two. Hey, see, for example, I wanted to sell this iPhone. Okay, I wanted to sell this iPhone. Offer can be given to whom? Offer can be given to anyone. Offer can be given to whole world. Anyone can come and buy the phone from me. Correct? But quasi contract law, generally offer will not be there. There is no offer. When offer is there, acceptance can be given by 1,000 people, 1 lakh people. But quasi contract law, acceptance offer will not be there. Therefore, always quasi contract law, right to money will be against one specific person only. Next, suit for its breach may be filed in same way in case of a contract. If there is a breach in the right to receive money as a normal contract, normally breach of contract, what punishment? Damages. Same thing will get attracted also in quasi. So tell me, 4 marks question came, quasi contract. What is a quasi contract? What you will write? First, point number one. In some special circumstances, an obligation resembling like a contract will be created, though really there is no contract. It is called as a quasi contract. Point number one. Okay. Point number two. That's a point one. In case of a quasi contract, there is very little or no affinity. Affinity means link. Okay, there is no affinity with contract in respect of mode of creation. Point two completed. Salient features. 5 salient features you need to write. What is the first salient feature? Point number one, no agreement. Second one, no only duty, no promise. Number three, it is a right to get money. It is a right to get money, not any performance of any duty, or not any performance of any activity. Number four, okay, number four, my right is available only against a specific person, not against any other person. Okay, if there is a breach in receiving that money, then you can file a suit like a normal breach of contract. Next, a minor was studying in MCom in a college. On 1st July 2019, he took a loan of 1 lakh from B for payment of his college fee and to purchase books and agreed to repay by 31st December. Okay. X possesses assets worth rupees 9 lakh. On the due date, X fails to pay back loan to B. B now wants to recover loan from X out of his X assets. Okay. Referring to the provisions of Indian Contract Act, decide. This is a question. Okay. So, point number one. Okay. Point number one. Minor contract. Normally, contract with a minor is not a legally valid at law. Means one party cannot sue. However, if any person has provided any necessity suiting to the life of the minor, general life standards of the minor case, if anyone has given any necessity like food, clothing, shelter, education, etc., that person who is giving that benefit can recover that amount not from minor but from the properties of the minor. Okay, so yes, B can proceed against assets of X according to section 68 of Contract Act if a person incapable of entering into contract or anyone who is legally bound to support is supplied by another person with necessities suited to his condition of life, the person who has furnished the supplies is entitled to be reimbursed. Since the loan is given to X is a necessary for his education, okay, his assets can be sued to reimburse to B. Over. Next, number three. P left his carriage on D's premises. Whenever question you read, now imagine a cinema. Okay, then only you will understand Contract Act. P left a carriage on D's premises. D house is there. Okay, I kept my bag in his veranda. Okay, landlord of D seized the carriage again as the rent due from D. P paid the rent and got his carriage days. Can P recover amount from D? Hey, see what happened. There is one fellow called as a D. D is living in a rental premises. P came and kept his bike parked in the veranda belonging to D and went out for 2-3 hours. By the time he came back, landlord of that particular house came and he said, "Arey, why you are not paying rent? I will take this bike." But actually, that bike does not belong to Dina. That bike belongs to P. P immediately ran to the landlord and paid the rent that this idiot has to pay and released his bike. And P wanted to recover that amount from D. Can he do so? In this case, quasi contract is created. Do you know why? There is a section which says that if what I have to pay on my behalf, if another person pay that, I have an obligation to pay to this fellow first. If X pay amount to Y on behalf of Z, then Z has every liability or a duty to pay to X. In reality, there is no contract created between P and D. Correct? There is no contract. But your duty of paying the rent, I have discharged to him. Therefore, my payment should come back to me again. So there is a duty, not a promise. Really, there is no agreement between both of us. So let us see all the conditions whether satisfied or not. There is no agreement, and there is agreement between D and P that I will pay your rent. Suddenly, it occurred as an obligation. Very good. There is a duty. Whose duty? That D's duty to pay back to P. What he has to pay? Money he has to pay. Okay. Only to whom? Only to P I have that obligation. Okay. If you don't pay, I will sue you. All conditions are satisfied. The classic example of a quasi contract. Final answer. Hence, being an interested party P made the payment and can recover the same from D. Next one. Next one. Quasi contract. What contract? Quasi contract. First, write about quasi contract. Whatever we read now. So, although there is no such obligations imposed by law, okay, it resembles like a contract. It has a little or no affinity. First, you have to write that paragraph. Okay, for this, they will give you 1 mark. Next, following cases are deemed as a quasi contract. Necessity supplied to a minor. Just now we saw na, in reality, there is no agreement between minor and another person. But for the necessity supplied to the minor, I can recover from the properties of the minor. Okay, next. Payment by an interested person. Just now we read that a person who is interested in the payment of money, which another is bound by law to pay. In my example, actually that idiot has to pay, D has to pay, but I have paid his amount. So I am an interested party in this contract of rent. Okay, in that rental, I am having interest now. Interest means I am having a interest to get back the money. Not interest means interest percentage illa. Interest means I have a concern to get back money. Okay, and who therefore pays it is entitled to be reimbursed. Completed. Next one. Obligation of person enjoying the benefits of a non-gratuitous act. Okay, what is this? See here. Next one is payment for a non-gratuitous act. Payment for non-gratuitous act. See here. Mr. A provided some benefit to Mr. B. Some benefit to Mr. B. There is no agreement between them, no consideration between them, but A provided certain things to B. Out of that, he got benefited. Okay, there is no agreement between them, but I don't have any intention to provide any free service to you. Okay, to provide any free service to you. Example, I will tell you. Example, I will tell you. I am running a library. I am running what? Library. In that library, so many books were kept. Okay, va? In that books, so many books that I am having. One of the book I gave you. Okay, one of the book I gave you. Not out of any gratuitous service. It's a non-gratuitous. You have to pay for that. Okay, va? So books are there. You have taken one of the book. Okay. Now suddenly one day you have taken for a, say for example, 1 week time. What a 1 week time. Okay. Then one contest was held in TV. They said that whoever have this book, if you can show that, send a photo that you are having this book, you will be paid 5,000 rupees prize money because that's a unique book. You have taken from library, na? You have taken from library, na? It's a bailment contract that is created. Okay, it's a non-gratuitous bailment. Non-gratuitous means what? There is no love and affection here. You have to pay money to me for the books that you have taken. So you send the photo and you got that 5,000. Okay, now what are the things that are there? See here. Where a person lawfully does anything for another person. I am librarian. I gave lawfully one book to another person, or it delivers anything. Book was delivered. Not intended to do its gratuitous, not out of love and affection. For commercial substance, I have given. Okay. And such other person enjoys the benefit. Because of having that book, you are getting a benefit of 5,000. The latter means the second person who got the prize money is bound to pay compensation to the former first person in respect of, okay, or to restore the thing so done or delivered. Simply you have to give back the benefit to him because it is not yours, it is belonging to that particular person. Okay, so when obligation, in reality there is no agreement between you and me that contest la money will come, you will pay me. Suddenly it happened, na? Okay, there is no agreement, there is only a duty to give back because it's not your book. Number 3, it is only a right to money, that 5,000 share I want. And next one, it is only against these two persons, not against any other person, because there is no open offer for this. Okay. And final touch is, if you do not pay, I will sue you. Next, responsibility of finder of goods. Same thing. Same thing. I lost my goods somewhere. Someone found it and brought it back. Okay. A person who finds the goods belonging to another and takes him into his custody and subject to same responsibility as if they were a bailee. Thus, a finder of the lost goods has, for example, I found your bag somewhere on the road. I took that bag. Okay, I am called as a finder of lost goods. I am not the real owner. I am the finder of lost goods. What is my duty now? My duty is to take proper care of the property as a normal person would take. I have no right to appropriate the goods. That means I have no right to use that particular goods and restore the goods if the owner is found. Okay, sir, is there any agreement that I have to take it to and give it to the owner? Agreement is not there, but quasi contract is created. If the owner is found, you have to give back. That does not mean you have to find the owner. Adilla. They are not telling that you should go and find the owner like a spy agent. No. If you find the agent, if you find the owner, you have to give it back and restore the goods to him. Next, money paid by mistake means what? In phone pay, most of the times by mistake, if one number changes, the money will go to another person's account. He is saying, I will not give you. You can file a case against him because quasi contract is created. He is having a duty to pay back. Okay. Next, what is a by the way, on finder of the lost goods, there is another question. Let's also cover that. See here. Rohan found a wallet in a restaurant. He inquired all the customers present there, but the true owner could not be found. Okay. He handed over the same to the manager of the restaurant to keep the wallet till the owner is found. After a week, Rohan went back to the restaurant to inquire about the wallet. Manager refused to return it to Rohan, saying that it do not belong to him. In the light of Indian contract, can Rohan recover the wallet from the manager? Okay. Other question. Now listen carefully. So one person's wallet, another person found. Okay. I found your wallet. You went out, your wallet I found. I asked everyone in the hotel, they said it's not ours. I went and gave to manager. Okay, now who I am holding it as a bailey. I am holding it as a bailey. Bailey means what? There is no real contract between me and the person who lost the wallet, but the moment I take the wallet belonging to another person, I am holding it as a bailey for him. So I am responsible for his goods now. Therefore, what I did, I went to manager and said that take this wallet. If the real owner comes, give to him. 1 week after, I went to the manager and said, he came. He said, no, no, sir. Then give it to me. I will find. He said, no, it's not even yours now. I won't give. You have to give because finder of the lost goods will have right to recover the goods, okay, from any person except the true owner. True owner, if he comes in, he should not tell, I will not give you. Any other person, he has a right to recover the goods back from them. So first you have to write about the finder of lost goods. 3 points. To take the proper care of the goods, not to appropriate, restore the goods, your owner is found. Okay. In the light of above, manager must return the wallet to Rohan. Since Rohan is entitled to retain the wallet found against everybody except the true owner. Means he can recover that from any person other than the true owner. If true owner comes now, you don't have any right to retain, give it to him. Okay. Quasi contract created. Next one. Now we are going into the next area called as contingent contract. See, these two questions are same. These two questions are same. Okay, contingent contract. So let us read only one point, one thing. Say, what is a contingent contract? Okay, a contract may be absolute or contingent, means guaranteed, unguaranteed. Okay, absolute or contingent. A contract is said to be absolute when the promisor undertakes to perform the contract in all events. Means what? There is no ifs and buts. Means what? If that happen or but this is the situation, therefore I cannot, like that it will not be. You agree to do that, you have to do that. That's called as absolute contract. But contingent contract is a contract to do or not to do something if some event collateral to such contract does or does not happen. Okay. Collateral means attached to it or additional to it. Okay. Okay. So it is a contract to do something or not to do something. Okay. If some event collateral to such contract does or does not happen. Okay. If a contract in which performance become due, if a contract in which performance become due, when to perform, it depends on happening or non-happening of certain event, we call it a contingent. So in case of contingent contract, performance is unguaranteed. Performance is unguaranteed. Contract performance is unguaranteed. It may happen, may not happen. So M contracts to pay N 20,000 if he is elected as president of particular association. It is a contingent because if that event occurs, then 20,000 performance will come into picture. Okay. Next, essentials. First one, hey, 5 points are there now. Must and should, you need to write the 5 points. There must be contract to do or not to do something. Performance depends on happening or non-happening. Happening of event is uncertain. May happen, may not happen. I may be elected, may not be elected. I may pass, may not pass. Next. Okay. Next. The event on which the performance is made to depend upon is an event collateral to the contract. That is, it does not form part of reciprocal promises which constitute the contract. Okay, the event should neither be a performance promise nor a consideration for the promise. See, read that point carefully. The event on which performance is made, listen to the line. The event on which performance is made to depend upon is an event collateral to the contract. It should not be the main part of the contract. Example, what they said there, M contracts to pay means M promises to pay N rupees 20,000 if he is elected as a president of a particular association. Let's say president. Now listen. Now, what is the uncertainty here? Appointment as a president. M promised to pay N. M promised to pay N. Okay, that is the performance. Okay, M promised to pay N. And how much consideration? 20,000 rupees. Okay, how much? 20,000 rupees. Here, appointing into a particular association is not a performance. Okay, I'm not paying 20,000 rupees for appointing as a president. If I become president, then I will pay you 20,000, I said. Here, M promising to pay N is a performance. 20,000 is a consideration. In these two things, contingency should not be there. Okay, so M said that I may pay you. Okay, I may or may not pay. Contingent contractor not created because the performance itself is doubtful here. Performance should not become doubtful. The performance should depend on some uncertain event. Performance should not become uncertain. Means what? Real A was appointed as a president here. Then also you may pay, you may not pay. Means then what is the point of that linking? So therefore, the most important point in contingent is the event on which performance is dependent on. Okay, is a collateral event. Means it does not form part of reciprocal promise. It does not form part. M promises to pay 20,000 to N. Okay, M promises to pay 20,000 to N. 20,000 is a consideration. M is promising that he will perform a contract of paying. In this, there should not be a contingency. They can link this to some event which is contingent. Okay, so the event should neither be a performance promise nor a consideration for the promise. That uncertain event should not be the performance or consideration. Okay, the contingent event should not be mere will of the promisor. However, where the event is within the promisor's will, but not merely his will, it may be a contingent contract. Okay, means what? For example, you said to me, I will be paying you 25,000 rupees. I will be paying you 25, or I am telling you, I will pay you 25,000 rupees. I will pay you 25,000 rupees for work done by you. Okay, for work done by you, provided I win a game that I play now. Okay, now what happens? Intentionally, I will not win the game. So it is in my will now. It is in my will. If I win, you will pay me money, na, or I will pay you money, na. Winning or losing is in my hands, na. Like that, you should not. Then intentional, I will not win. Therefore, contingent event should not be the mere will of the promisor. Will means intention of the promisor. However, where the event is within the promisor's will, but not merely his will, it may be a contingent contract. Next, meaning already we completed contingent. Let us see one question and close this. PQR, a hospital in Delhi, recruits Dr. A on a contract basis for 3 months. Okay. The hospital management promises to pay Dr. A lump sum amount of 1 lakh if Dr. A tests positive for nodal coronavirus during the contract period of 3 months. Identify the type of contract and highlight the rule of enforcement. Okay, this is the question. Read the question first. Read the question. So what happens in this question? PQR is a hospital in Delhi. It recruits Dr. A on a contract basis for 3 months. They said that, alright, Dr. A, if you are contracted with, means if you are attacked with COVID virus, I will pay you 1 lakh compensation for you. Okay. They said this is the thing. You may get contracted, you may not, but we will pay you. So now promise is made by one person to what is a contingent contract? It is a contract to do or not to do something. If some event collateral to such a contract does or does not happen, first we have to write this to get that 1 mark. Next, it also says that contingent contract to do or not to do anything if specified uncertain event happens within a fixed time. Sir, what is all this? I will tell first and then you read. Then you will understand. See, in this case, what happened? PQR hospital in Delhi recruits D, Dr. A as a contract basis doctor. They said I will pay you compensation of 1 lakh if you are contracted with COVID virus. Okay. Now payment to him depends on uncertain event of whether he may get contracted, he may not get contracted with COVID. They said that 3 months time they have given. In this 3 months time, if you are attacked with COVID, we will give you 1 lakh rupees, they said. Now it is a contingent contract. It's a contingent contract. You have an obligation to pay me at the performance, and amount is certain, and payment to me is certain. But the payment is linked to a collateral event which is uncertain. Okay. Now that specific event is there now, attacked by COVID, contracted to COVID. That does not happen. What will happen if he does not contract? So if that specific event does not occur within the time period fixed, contract becomes void. So that's what he said. If a specific uncertain event happens within fixed time, becomes void if at the expiration of time fixed, such event has not happened. And in your language, how to write? If the specific event which is collateral to the contract does not happen within the time frame, then the contract will become void. So normally, first you need to write that it is a contingent contract. Next, what you need to write? Okay. Next, in case if Dr. A does not contract with COVID-19, then contract stands void automatically. Void automatically. Understood? Okay. Last question. Explain the term contingent contract. First, you have to write contingent contract. See, every question they are asking what is a contingent contract. A contract to do or not to do something if some event collateral to such contract does or does not happen. First, 1 mark. Next, enforcement. See here. Also discuss the rules relating to enforcement of contingent. Enforcement means performance of a contingent contract. Okay. So when we will perform a contingent contract, two things. Two things. Sometimes I can tell like this. I will do this if that event happened. I can also tell I will do this if that event do not happen. Okay. So we both promised together. I said that I will sell you 100 bags of rice. I will sell you 100 bags of rice. Okay. And you will pay me 1 lakh. Provided both will be doing all this, provided if stock market goes up by 100 points that day. Now me giving you a rice bags is guarantee. You giving me 1 lakh is guarantee. But both are linked to one uncertain event, na? 100 points. Once that really 100 points cross, contract becomes enforceable. Okay, see. Where contract identifies happening of future contingent event, the contract cannot be enforced until and unless the event happens. Okay, until Sensex increases by 100 points, contract will not be enforced. Okay, if the happening of event becomes impossible, 3:30 day only over, trading stopped. After that 100 points crossing is impossible because market is closed. Then the contingent contract, but then the contract becomes void. It will close. Next, enforcement of contracts on event not happening. I said like this. I will give you 1,000 rice bags. You will give me 1 lakh. Provided Nifty do not cross 100 points. Do not cross 100 points. Now negative. Not happening. So really did not cross. Then contract becomes enforceable. But it crossed. Then I will not pay you. Okay. So where a contingent contract is made contingent on non-happening of event, it can be enforced only when it's happening becomes impossible. Means on its non-happening, contract becomes enforceable. Next. Sir, if it is impossible, that event may become impossible, then also it will become void. Just so we write a fixed time period, COVID, all this. These are the 2 points. Okay, contingent contract to do or not to do something if a specified uncertain event happens within fixed time becomes void if at the expiration of fixed time such event has not happened. COVID example. Same point here. Contingent on impossible event. Contingent agreements to do or not to do anything. If impossible event happens or void, whether the impossibility of event is known or not known to the party. Simply to tell, whenever you are creating any uncertain event, you are not creating uncertain event, you are creating impossible event. I said like this. I will give you 1,000 bags. You will give me 1 lakh. If sun rises on west, it is a contingent, impossible, obviously impossible event. It starts as a void contract. Okay, this question already done. With this we completed contingent contracts and quasi contracts. Okay, prepare well for the exam.